Okay, Chair, we're now live.
Lovely. Thank you very much, Will. Okay, so good morning, everyone, and welcome to this virtual licensing subcommittee meeting, which is being conducted with members, officers, and members of the public at various locations, communicating via audio, video, and online. There is also the opportunity for the public and press to listen and view the proceedings. Before the meeting starts, I'd like to invite our committee member and scrutiny officer to explain how proceedings will work and to confirm that members and officers are in attendance. Before I pass over, just a polite reminder, if you're not speaking, please make sure that your microphone is on mute, and when you want to speak, make sure that you unmute yourself when you're invited to do so.
Thank you very much, Chair. Please note that this meeting is being streamed live onto YouTube and recorded via Zoom. When your name is called, please indicate your attendance to confirm that you are present and can hear and be heard. So we're going to start with the panel. Do we have Councillor Dennis Harburg?
Yes.
Thank you. Do we have Councillor Bloxham?
Yes, thank you.
Thank you. Councillor Morris?
You do, yes.
And our reserve member, Councillor Thake?
Yes, here, thank you.
Thank you. Now I'm just going to go through our officers. So do we have Jasmine Jennings?
Yep, here.
Thank you. Steve Cobb?
Present.
Thank you. Naranetta Kativu?
Present.
And Arhamna Jaffrey?
Present.
Thank you very much. Do we also have members of the Hertfordshire Constabulary with us?
Sergeant Chris Adds, head of the Community Safety Unit. I'm here and present and hearing you.
Very much. Do we have any others?
Yes, Koldrick Sanger, licensing officer, present.
Thank you. And do we have the applicant?
My name's Piers Warren from TLT Solicitors, and I represent Green King, who are technically the applicants, but there are other parties here representing the DPS Dale Mabbutt. But also I have Andy Turner from Green King here as well on the call.
Okay, thank you. Could I just check, Andy Turner, can we hear you?
Yes, I hope so.
Thank you. And Dale Mabbutt?
This is Tom Day. I represent Dale Mabbutt. I can see he's here, but if he is speaking, he's on mute. Mr. Mabbutt, you're still on mute. You've off
Is that
mute.
better? Can you hear me?
Yes,
we can hear you. Yes, thank you very much. Is there anyone else I haven't mentioned that is present here?
We have Grace Davies, who's mine solicitor.
Thank you. Shall I just check that your microphone is working, Grace?
Oh, yeah, yes, thank you.
Thank you very much. Is there anyone else? Okay, thank you very much. The hearing preliminary, which details the arrangements for the hearing, has been uploaded to the internet as a supplement to the agenda. I'll just run through this briefly. The subcommittee consists of 3 voting members with a 4th non-participating member listening to the hearing. In the event that a voting member loses connection, the hearing will adjourn until connection can be restored. If the adjournment exceeds 10 minutes, or it is apparent sooner that reconnection will not be possible, the 4th member will replace the absent member and become a voting member of the subcommittee. If a quorum of 3 members that have been present throughout the hearing is not possible, the hearing will be adjourned. In the event that the applicant loses connection, the hearing will adjourn until connection can be restored. If it becomes apparent that reconnection will not be possible, the hearing will be adjourned to a stated date. In the event that the responsible authority loses connection, the hearing will adjourn until connection can be restored. If it becomes apparent that reconnection will not be possible, the hearing will be adjourned to a stated date. If the responsible authority has completed their presentation and closing statement before losing connection, the chair may decide to continue with the hearing. The subcommittee will undertake their deliberations in private, and the aim is that they will return to announce their determination on the live stream. However, they will not wait until all parties are connected. A copy of the decision will be forwarded to all parties electronically as soon as practicable, and will be able to be viewed on the Council's YouTube recording of the meeting and uploaded to the Council's website. If, having retired, members believe that the deliberations for a decision will take too long, to avoid parties waiting, they may decide not to announce it live on the day. If this is the case, an announcement will be made to this effect and the meeting will be closed. The decision would then be announced in writing within 5 working days of the meeting. Are there any questions before we start the meeting? No, I will now hand back to the chair.
Lovely. Thank you very much, Louis, for that very full and thorough introduction and explanation of things. So my role is obviously to welcome everyone to this meeting. And before we get into detail, I'll just introduce the other people who are going to be involved in hearing this case. I'm Councillor Elizabeth Dennis-Harburg, and I will be chairing this licensing subcommittee. I will be assisted by my colleagues, Councillor Gerald Morris and Councillor Simon Bloxham on the panel, and Councillor Richard Thake is our reserve member. Our licensing officers, as you know from the introductions earlier, are present. Jasmine Jennings is acting in that capacity today, and our licensing manager, Steve Cobb, is also on the call. We're joined by members from Hertfordshire Constabulary, and we also have peers acting on behalf of Green King, which is the applicant, and Mr. Tom Day is representing Dale Mabbott as the potential designated premises supervisor. We've also got Grace Davies as the instructing solicitor, providing additional support should we need. I think obviously we've got Dale present as well. Thank you very much, Dale. It's good to have you here. So the procedure that we're going to follow today is going to be slightly different, I think, to how we would normally run these. I'm going to take the legal advisor's considerations, and then I will ask the licensing officer to present her report, and the subcommittee will ask, and we all have the opportunity to ask Jasmine questions. And then I think what I would like to do at that point is for us to move this hearing into a closed session, because there's some additional evidence that I think it would be appropriate and relevant for us to consider, and it's right and proper that we do so in a closed session. After we've done that, then I think we can come back into this main public-facing part of the hearing, and we can hear from the constabulary and they can set out their case. We all have the opportunity to ask questions of the constabulary, and then we can hear the applicant's case. I'm not sure whether in this instance, Piers, you're going to be putting forward a case for Green King, or if it's more appropriate for me at that point to hear from Piers. If you want to make a decision and advise me when we come to that part of the agenda, I'm happy with that. After we've heard from the applicant and the premises supervisor, potentially, we will move into our closing statements, and then we'll wrap things up. I'll hear final advice from the legal advisor, and the subcommittee will retire to consider things and to reach our decision. And depending on how long we take, obviously we'll come back into session or whatnot, and we will let everybody know. So in that case, I will ask us now to have the legal advisor outline the matters for consideration during the course of this hearing. So I think that's Ahamna that's going to be doing that for me today.
Hi, sorry, I think Steve, you're doing the opening.
Yes, so sorry, Chair, to mess up your order, but I'm going to do an opening statement that covers off my comments and the legal advisor's comments.
Instead of pulling faces, because no one can see, I'll acknowledge that verbally, sorry. Okay, thank you very much, Steve. It would have been nice to have that on my running order. Off you go.
It would, if only I'd have typed the running order, but oh, I did. Thank you, Chair. There's no change to the documentation published on the Council's website as part of the hearing, but as you would imagine, I have a number of comments to make. Mr. Warren, the legal representative of the premises licence holder, Green King, has sent an email explaining his role at the hearing today, and it has been circulated to the subcommittee in advance. As a party to the hearing, he is entitled to address the subcommittee, ask questions where appropriate, and can be questioned, but the subcommittee should draw no inference regarding his reduced role today. Part of the police representation was redacted in the public domain, although it has been provided to the subcommittee and all parties, as it relates to CCTV footage, which is part of an ongoing police investigation. Regulation 14 of the Licensing Act hearing regulations allows the subcommittee to exclude the public from any part of the hearing if they believe it's in the public interest. So, Chair, you are quite entitled to go into a closed session, and it's your choice who remains in that closed session. At the conclusion of the discussions in the closed session, the subcommittee can then return to open session and discuss the remainder of the representation that wasn't redacted, which relates to Mr. Mablett's convictions, which are in the public domain and don't need to be discussed in closed session. To assist the legal advisors representing Green King and Mr. Mablett, they were shown the CCTV footage yesterday in a closed session so that there are no surprises today. Today's hearing is very unusual in that it is only the second time since the Licensing Act took effect in November 2005 that the Council has received a notice of objection to a DPS. There are only two options open to the subcommittee today: to grant the application or refuse the application. There is no provision for adding conditions or amending the premises licence in any way. That determination should be based solely on whether or not the subcommittee believe that appointing Mr. Mablett as DPS would undermine the licensing objective of the prevention of crime and disorder or not. The Act states that the police must be satisfied that there are exceptional circumstances to justify an objection. However, no further detail of exceptional is given in the Act. The dictionary definition of exceptional is either unusual or not typical. Looking at the annual licensing report published on the Council website, it shows that in the last 4-year reporting period, the Council has received 326 applications to vary a DPS, but none of those 326 received an objection notice. So I submit that the fact that we have an objection notice today does meet the test of an exceptional circumstance. The subcommittee reminded that this is a civil hearing with the evidential test on the balance of probabilities. Whilst the redacted information and CCTV refer to an ongoing investigation where no charges have been laid, criminality does not have to be proven for the purposes of this hearing today. The subcommittee must only have regard to evidence presented during the hearing, including the advanced written submissions, and ask themselves, I submit the simple question: would the appointment of Mr. Mablett as DPS for the premises have an adverse effect on the promotion of the prevention of crime and disorder objective? Perhaps put more simply, does the subcommittee believe Mr. Mablett is a suitable person to be in day-to-day control of the premises and ensure the promotion of the prevention of crime and disorder objective? If the subcommittee believe that the licensing objective will be adequately promoted, they must grant the application. If they believe that the prevention of crime and disorder objective will be undermined, they must refuse the application. Happy to take questions at any time during the hearing, Chair.
Lovely, thank you very much. Now, I'm going to assume from what I've heard that was a combination of the legal advice and the licensing officer's report.
It was a joint effort to streamline the proceedings, Chair.
Okie dokie, in which case then you will know that I am now going to ask if any other persons, that's an odd way to, any other persons objecting to the application, so I think that would be the constabulary, have questions to ask of Mr. Cobb.
No questions to ask of Mr. Cobb, thank you.
No questions. Thank you very much, Chris. Okay, and now I need to ask whether Mr. Day on behalf of Mr. Mablett or Mr. Warren on behalf of Green King would like to ask questions of Mr. Cobb.
Thank you, Ma'am. Can I ask one question? It's really to provide hopefully some clarity in relation to the law. The question of whether the police have objected in exceptional circumstances, I just want to ask Mr. Cobb, isn't the same as the question of whether the police commonly or rarely object. And would the legal advisor agree that it's not about how frequent it is, it's about whether there are exceptional circumstances in a particular case? They're two distinct issues. One is rarity and one is whether there are exceptional circumstances in this case.
I'll go first, if that's okay, Chair, to buy
Okay.
Hamler some time. The Act specifically mentions the word exceptional, but it doesn't define it. And so it's for the subcommittee to determine what interpretation of that word they use. And no doubt there'll be some representations from parties on what they believe exceptional means. In the absence of guidance, I just looked at the dictionary definition, which says unusual, not typical. And given that we've only had two since 2005, I think this is certainly unusual or not typical of the police's role in determining whether or not to object to a DPS.
Thank you. Hamna, did you have anything to add?
Nothing to add to that. Thank you.
Okay, thank you very much. So I think, Mr. Day, the clear instruction there is persuade us and argue your case on that point if you believe it's going to be relevant in this proceeding.
Thank you.
Thank you very much. Okay. And do members of the subcommittee have any questions of the sort of combined legal and licensing report?
No, I'm fine.
No, lovely. And I see shaking heads from Councillor Bloxham and Thake as well. In which case, then, I think what I propose to do at this stage, because to my mind it makes most sense to do this before we get into the substantive considerations of this particular application and the responses to it. I think we ought, if everybody's agreed on this subcommittee, to move into closed session. And I propose that all members that I can currently see who are present on this virtual committee ought to come with us into that virtual closed session so that we can have the maximum benefit of input from this part of the hearing. So could I ask Louis to assist us getting that sorted?
Yes, you should have an invite coming to you now.
Okay. Will or Louis, could I ask you to sort of formally make sure that everybody's back and run a roll call for us, then we can get going.
Okay, I'll take that on. Again, in the order that you appear on my screen: Steve Cobb,
Present.
Richard Thake,
Yeah.
Andy Turner,
Present.
Alice Ashbrook,
Here.
Arhamna Jaffrey,
Present.
Simon Bloxham, Yeah, thank you. Dale Mabbott, Mr. Mabbott,
Sorry, I was muted. Hi, I'm here.
hi there, thank you. Councillor Dennis Harburg.
Yeah.
Sorry, people are moving around. Nurinetta Katavu,
Yeah.
Tom Day,
Here.
Grace Davies, Koljit Sangha,
Yeah. Sorry.
thank you very much. Piers Warne,
Yeah, thank you.
and Chris, sir, from Hertford's Constabulary.
Yeah, yeah.
Great, thank you very much. I believe that's everybody.
Lovely, thank you very much. I will ask if there's anybody that Will's missed and that we haven't heard speak, because clearly if there's somebody that's been missed and isn't here, they can't answer. Okay, I think having looked at who I'm expecting to be present, I have everybody in this hearing that I'm expecting. So, having considered the evidence we needed to review in closed session, we now need to move on to the main consideration of the matter before us, and the first part of that is to hear the case from Hertfordshire Constabulary. So if you could make that, obviously, if you do need or feel necessary to refer to what we've considered in the closed session, please do so, but do so in a way which doesn't breach any potential confidentiality issues which might apply.
Thank you, ma'am. I am Police Sergeant Chris Adshead of Hertfordshire Constabulary, and I'm the Community Safety Unit Sergeant for Stevenage and North Herts, and I act as first line manager to the licensing officer who acts for North Herts, which is Koljit Sangha, who's also here. I'm attending today on behalf of the Constabulary to make representation to oppose the proposed change of DPS to Dale Mabbott at the Engine Public House, which is in Station Road in Baldock. I'm going to keep this outline very brief, as all parties had the information regarding the evidence for this, so they've had it in advance. So I'll keep it brief if that's okay. The basis of this representation is that the police received a change of DPS application under Section 37 of the Licensing Act 2003 in respect of Mr. Mabbott, but we believe the change would undermine the licensing objective of prevention of crime and disorder, and do not consider Dale Mabbott as a fit and proper person to hold such a position. Having completed and reviewed our police checks on Mr. Mabbott, and after very, very careful consideration, we've made representation in the evidence which is already with the committee and which I won't be referring to further. There are convictions, in addition, which are public knowledge and public information. Mr. Mabbott has, as you know, been convicted of an offence of Section 4A of the Public Order Act. There are other offences, and I don't believe, for the benefit of this public session, to go through them. I don't intend to go through them, but I will bring them as part of the representation to the note of the panel and of the committee today, unless you wish me to list them, in which case I will. The police are also in possession of footage which has been submitted to the committee for consideration, and we formally submit that as part of our representation. All of the evidence presented highlights the behaviour that Dale Mabbott has presented previously, and therefore seriously brings into question his suitability to act as a DPS for the Engine Public House. I did say I would keep it brief. I'm I don't intend to make a lengthy representation on the evidence because you have it before you, but we would ask the subcommittee to consider refusing the application strongly, and the evidence I have mentioned is submitted for your consideration.
Wonderful. Thank you very much, Chris. It's almost as if you've been to a hearing that I've chaired before. I think in reference to the question that was contained in there, I don't think it's necessary for you to list all of the convictions. We do have those in the submissions anyway, and it's more a case of considering whether these convictions are relevant to the questions that we're considering today. And we do, as I've said, have the list of them here before us, and we can make our own determination based upon that. May I then ask if there are any questions for the police? Again, my running order says from the applicant's representative, but I'm going to jump around Piers, if that's okay at this point in time, and ask Mr. Day if you have any questions for Chris.
No, thank you, Mum.
No, thank you. Okay. Piers, I'll come to you second. Does Green King have any questions on the police report?
No, thank you, Mum.
No, thank you. Excellent. In that case, I will move to members of the panel. Councillor Bloxham.
Thank you, Chair. It's really just to see if there is anything else that we are needing to take into account that affects this his particular role. We've been given some information on convictions, all related around one particular area. But is there anything else? And I would also like to ask is if we have a particular pub that is a problem to the police and has been a continuing problem to the police.
Okay, thank you. So I think there were two questions in there. One of them is, I feel, almost procedural and for licensing officers to advise the panel on. So I'll park that for now and hold on to it, and I'll ask Steve potentially to advise on that. However, Chris, could you comment on the query around problem pub?
You'll have to repeat it because I didn't quite get the second part of the question, if you wouldn't mind.
Yeah, sorry. It's really to do with is this known as a pub that's a troublesome pub? Are you called there quite often? Is there a lot of issues coming from that pub other than what we've just seen?
If the chair is happy that I can answer that in terms of relevance to this.
I think I am, because I'm almost minded to look at a course of dealings and conduct over a period of time. So I think that if it is relevant to this particular premises supervisor, it would be appropriate to provide some additional information.
Okay, in that case, apologies, I'm having a slight technical hitch here. In that case, I think it would probably be better for me to ask Kuljit Sangha, who is on a day-to-day basis deals with the licensing of premises, to answer that. The short answer would be yes, there are concerns around that premises, but I'll ask Kuljit to comment further.
Okay, Kuljit.
Hello. Yes, there have been quite a few public order incidences, including crimes of assault, which have had to be investigated. I apologise for my dog in the background. So we have had to get to the point where we've had to have meetings with Dale, and we had a conversation with the area manager, Andy Turner, as well, around the public order issues and how could they be resolved. However, we've not had another meeting with the DPS, Dale Mabbott, and the area manager due to unforeseen circumstances involving Dale not being available. And that's really all I can add at the moment.
Okay, thank you very much. Steve, did you want to give Councillor Bloxham a little bit of advice on the first query that he raised there about issues to consider?
Yes, certainly. Hang on. Just turning my camera on so not to be rude. The simple answer is you can consider any issue that's put before you today, but you are obviously limited to the the information presented by the police. So if there are other issues relating to the premises and they haven't been presented to you today, then obviously you can't consider them.
Okay, thank you very much. I think everybody heard that. Councillor
Madam Chair,
Morris.
in that case, may I just come back on that? I do apologise for interrupting you. So sorry.
Go on then, I'll allow it.
Thank you. Yes, in that event, without going into specifics of occasions, the engine has been known to the police as a public order issue for some time. We hold a public order briefing, which is for the teams who book on for public order evenings in order that they quite sensibly have information around our hotspot venues. Sometimes it is not of the premises own making. They do a lot in order to prevent disorder, but there are certain venues which attract disorder. Or not just disorder, but also there is obviously the nighttime economy has issues with drugs, etc., etc. And some premises attract a clientele which effectively may promote crime and disorder by default. The engine has featured regularly on our public order night briefings. I'm not casting aspersions when I say that. It's a factual piece of information. Recently, Mr. Mabbott, as Colgett said, was indisposed, I believe, for a time, and effectively the DPS was handed over, which is why we're here today. The person who took control and became DPS during that time, significantly, the interventions that police had at that premises dropped considerably. I was at a meeting as well with Colgett and the brewery's area manager prior to those events, or during that time when Mr. Mabbott wasn't available to speak to us, and we made representation quite clearly to him about our concerns at that time. So if it is allowable and it is representative of the situation we find ourselves in now, we made those considerations known at the time to the area manager and were quite clear on the fact that we needed to work hard with Dale and that premises to, for want of a better term of phrase, a colloquialism, I suppose, to clean up the act there. And we did make that representation. And if that gives you some background that's submissible, then I hope that's helped.
Thank you very much. That was useful and relevant. Gerald, you had your hand up, but you've put it down. I'm assuming that, did Chris deal with the point that you had just then? You're on mute, Gerald.
Sorry. It's all the questions. Thanks, Chair. The questions have all been answered. Actually, I had the same questions as well by Councillor Bloxham. Thanks.
Perfect. That's great. Thank you very much. Councillor Thake.
Yes, Madam Chair. More of a statement, I think, of concern. I realise we're not a court of law, and of course, I am not a qualified advocate. Although, in the course of my nearly 80 years, I've attended many sessions. I have to say, hopefully on the right side of the dock. But I am very concerned about the quality of the statement which we've just had from the police in terms of the capacity of the applicant and his representatives to respond meaningfully to it. I give you an example. The fact, and I accept it is a fact, that there was a change in the number of incidents and when Mr. Mabbott was not the acting individual that he now is. There are many manifold reasons why that could have happened. COVID, the pub may not have been active. I don't know. He can't refute it. I can't refute it, and I can't give it any weight, I'm afraid. I feel it would be not proper for me to give that weight on the basis that there's no evidence that Mr. Mabbott was responsible for that period of time. In fact, he wasn't responsible for that period of time. So I'm just making a statement so that everyone understands I'm trying to be incredibly balanced here in a difficult situation, and to be absolutely fair. At some stage in this morning, we are going to have to come to a conclusion. And I would like that conclusion to be reached with a balanced attitude.
Lovely. Thank you very much for your statement in the questions section. And I think that that is a comment that is valid and would be something that we would discuss and debate in deliberations. So it's nice to show the workings of the committee somehow and how transparent we might be. Okay. And I also think that the police have heard the point that was being made there about how they present their statements to this committee, subcommittee, panel, authority going forwards as well, and how beneficial that might be to members in making our decisions. Right, I do not have any further questions for the constabulary, and I trust members don't have any either. So I will then move to hear the applicant's case, which I'm assuming is going to be Mr. Day presenting.
Mom,
Chair, sorry, Chair, and sorry, Tom, for cutting across you. As the applicants, we do have a couple of very brief statements that might assist the committee, and I'm very aware of your sharing of these matters before I've come before you before. But there's two matters of fact that I think set some context and two matters of law that I think are important to set context from the applicant's point of view. If you're happy for me to...
I am more than happy for you to present that, Piers. It's your point in the programme. So this is the exact assistance that I needed from you today. So we shall take Green King's case and we'll run the usual questions on Green King, and then we'll move on to Mr. Day representing Mr. Mabbott. Okay.
And I hope Mr. Day's happy with that. I know he was gearing up, ready to speak, but apologies to him. So the 2 points of fact of this. Dale has been the interim DPS, which is a position appointed under the Licensing Act, Section 38, since the application was made in this case on the 7th of December. So he has been effectively de facto DPS at the premises for 6 weeks or so now. I think that's an important point of fact to note. Secondly, Green King's obligation obviously is to submit an application on behalf of our tenants. Dale is a tenant of ours. This is so he's not an employee of Green King. Which is why I will be handing over, obviously, to Mr. Mabbott's counsel to deal with the substance of the case. But there were 2 points of law that came up, one in the submissions of the officer at the very beginning, and then a second one that actually Councillor Fake has raised, and I feel I do need to just address very quickly. So the points of law are these. We were talking about what is exceptional and not, and you asked yourself, Chair, to be addressed on this point as a submission point. Section 37.5, which is in your papers, so it's quoted there, but it effectively says where a chief officer of police is satisfied that the exceptional circumstances of the case are such that granting the application would undermine crime prevention objectives, he has to give a statement to that effect. So actually, the exception is not to do with whether this has happened 100 times, 50 times, 10 times, or once. The exception is in this particular case as to whether the facts presented to you mean that Dale should not be DPS. So that is the exception. And taking into account my submission is anything around the number of times the police have made it is irrelevant, simply because we don't know what was in their minds at the times they chose to or chose not to. The second point of law, and I'll deal with this very briefly, is about submissions now in this hearing of crime and disorder at the premises that have not been made in a representation. You know this very well, Chair, and your committee members do, that the Licensing Act and the guidance is all based around the idea that no side should be blindsided. No side should be put on their feet to deal with any representations that aren't made in submissions prior. And as Councillor they absolutely and quite rightly pointed out, those submissions do not appear in the police representation. Which means that obviously Dale and his counsel don't have a chance to respond to them. And therefore, I'm going to submit that the weight given to any submission of that nature, and especially how general they were, should not be given much weight in the deliberations. Those are my points, Chair. And on that point, I would hand over to Mr. Mabbott's counsel.
Lovely. Thank you very much, Piers. Right, so usual round of questioning. I will turn first to the constabulary. Do you have any questions for the applicant?
No questions. I would just point out I wasn't making testimony. I was simply answering a question put to me, but no questions.
Okay, thank you. When I ask for questions, everybody, including councillors, I expect them to be questions. Noted? Noted. Good. Happy. Mr. Day, do you have any questions for the applicant?
No, thank you.
No, thank you. Okay. And members of the subcommittee, do you have any questions for Piers?
No, thank you.
No, thank you.
No,
Thank you.
No.
Thank you.
Excellent. Thank you very much. And you'll be unsurprised to hear that I have no questions for you either. Thank you very much, Piers. That was useful. Mr. Day, would you like to present the premises supervisor's case? And then obviously the usual questions will follow.
Thank you, Ma'am. And can I thank Mr. Warren for his comments? They say what I was about to say, but I take it one step further, if I may, in this respect. I agree entirely with Mr. Warren in relation to the exceptional aspect. It's about whether the facts of this case are exceptional. And in my submission, the responses given by Sergeant Adshead in relation to history should be given no weight at all, and they should essentially be deemed inadmissible. And there are two reasons for that. As Mr. Warren has said, it's the consequence of being blindsided, but it's more than that. It's the fact that there is no way in which they can be challenged or questioned, such is the vague nature of them. If, and this is a significant factor, there were concerns about the prevalence of crime and disorder at this venue, then we all know that the police authorities have the power to seek a review of the license. There has been no such review sought. You'll know from your paperwork that Mr. Mabbott has been the designated premises supervisor at the Engine Public House since the 12th of November 2019 until the 13th of October 2021. Thereafter, he removed himself as the designated premises supervisor until the 7th of December 2021. So we are talking about a period of approximately 7 weeks. Now, the proposition by the police, the objection to this variation of DPS, is that Mr. Mabbott in his private life has undergone or has received convictions. That is an undeniable fact. Mr. Mabbott pleaded guilty to those matters. And in my respectful submission, they have little to no bearing upon the performance of his role as a designated premises supervisor. One has to, in my submission, base this entirely upon the representations made by the police. And it amounts to this: the matter that you have seen in closed session and the convictions that you have. That is the entirety of the evidence, which in my submission, that this body can lawfully take into consideration. And the question must be asked, what relevance is there in the conduct of Mr. Mabbott in his private life, such as you've heard, led to those convictions, and the performance of his role as a DPS, such that the police say it would undermine the prevention of crime and disorder objective? The answer to that is unknown. There has been no link made between those convictions in his personal life and the performance of his role as a DPS. The response seems to be that he's not a fit and proper person. But I'm sure you and your colleagues will be aware that that is not a test which you are to apply. The test that you apply is set out in Section 39 of the Licensing Act. And it says this: subject to subsection 3, the relevant licensing authority must grant the application. And subsection 3 says where a notice is given under Section 37.5, they must hold a hearing to consider it, and having regard to the notice, reject the application if it considers it appropriate for the promotion of the crime prevention objective to do so. So the only test is this application to be rejected because it's appropriate for the promotion of the crime prevention, the prevention of crime objective. The fit and proper person is not the law. It may have been some 20 years ago, but it's not the law now. And the role of the DPS, as we all know, is in essence this. The DPS has the primary responsibility to ensure that all staff sell alcohol legally, in line with both the law and the license that is attached to the premises that they are in charge of. You have heard nothing to suggest that in his performance of the role of DPS, Mr. Mabber has failed in that respect. You have heard in private session something to suggest, although not accepted, that in his performance of a different role, he may not have acted as some may have hoped. That is not the same as the performance of his role as a DPS. And if further proof were needed of the disparity, the category error that's being made in this case, it's right to note that the Licensing Act sets out at Schedule 4 a series of relevant offences. Those are relevant offences that if an individual has been convicted of them, then the magistrate's court is duty bound to notify the authorities, and in fact, it has even more significant effects than that. Those offences include, for example, the ones you would expect: selling alcohol to someone underage, or breaches of various aspects of what you would expect a DPS to perform. None of those are covered by the matters that Mr. Mabber has been convicted of in his private life. And it comes down, in my respectful submission, to something as simple as this. Can Mr. Mabber, despite his conviction in his private life, perform the role of a designated premises supervisor appropriately? Of course he can. Does the conviction in his private life in a personal matter affect his ability to ensure that when the Engine Public House sells alcohol, it does so in accordance with the license and with his legislation? No, it has no impact whatsoever. One, quite frankly, could be the best designated premises supervisor in the land, and yet in their private life have acted badly. And so in my respectful submission, the matters you have heard of have little to no relevance at all. In relation to the matters that you heard of in private, in my respectful submission, they are more relevant to the question of approval by the appropriate regulatory body than they are to the performance of his role as a DPS. And in any event, it is, if I may say, very much unclear as to quite how bad it would be. And in relation to those private matters, can I just ask you and your colleagues to avoid the consequence of hindsight bias? We know what happens towards the end of that in terms of the numbers of people who attend, but it seems to be suggested that that was obvious from the word go. And it's not. That's hindsight bias. And so in my respectful submission, if one applies the law appropriately, one has to bear in mind, as Mr. Warren has said, that Mr. Mabber has operated as DPS since the 7th of December 2021. He had operated as DPS of this premises for very nearly 2 years beforehand, and that there is nothing in the representations that can be admissible and used in this case that would suggest that he has failed to perform that role in all of that time. I will be blunt, because we've spoken unclearly about this, about why Mr. Mabber was no longer the DPS, because this is an accident of his circumstances because of his behaviour in his private life. But Mr. Mabber had bail conditions such that meant he couldn't be in the area where the Engine pub is. Mr. Mabber could have sought to remain as DPS, even though he wasn't able to attend the premises. But Mr. Mabber, recognising that the performance of DPS will more often than not require the DPS to be on site to perform it properly, considered it appropriate to remove himself as DPS so that the performance of that role could be done. That is the only reason why we are in this situation. And the exceptional circumstances that the police seem to rely on for their objection in this case is that Mr. Mabber has been convicted in his private life of matters unrelated to the performance of the role. And so in my respectful submission, the only matters that can be taken into account are in the representation. if the licensing authority wishes to take into account any other generic matters that have been raised, the principles of natural justice would require that those are specified, that we are given advance notice of them so that we can challenge them, and any weight that they may be due can be given. But absent that, no weight can be given to them. Ma'am, I believe that's all I propose to say. Forgive me if I'm sure. No, thank you, Ma'am. That's what I propose to say.
Okay, lovely. Thank you very much, Mr. Day. That was of assistance. Okay, so may I turn to the constabulary for any questions? Questions, not statement, not back and forth, pure question, please. Thank you. Of Mr. Day and Mr. Mabbott.
Yes, it's Sergeant Adshead. You'll have to forgive me. I'm not a legal expert, but my question would be, given the quotation under the law, the government's own guidance on the Licensing Act, and in particular the responsibilities of a DPS, are quite well stated. So could I just ask whether or how how is Mr. Mabbott undertaking the following, which are from that guidance? And how does he, as a DPS, given the evidence that we've seen in private session, how does this apply? And it says they must understand the social issues and potential problems associated with the sale of alcohol and have a good understanding of the business itself. And under the heading taking responsibility, it states this is because the impact alcohol has on the wider community, on crime and disorder and antisocial behaviour. Because of these, selling alcohol carries greater responsibility than licensing regulated entertainment, etc. And my question would be, how does he address those issues in rejecting this application?
I think we can both see what the attempted question was there. Do you want to have a crack at it, Mr. Day?
I hope I've followed it. Mr. Maber, as he has done in the years he's been the DPS, is careful to ensure that there are sufficient security on staff for the appropriate circumstances, given the size of the venue, the nature of the event. Mr. Maber, of course, also knows very well his responsibilities to ensure the health and safety of his clientele, and you've seen evidence of that in the private session matter when I've indicated how the situation arose. He is entirely aware, and so are his staff, that it is their responsibility when serving or delivering alcohol to ensure that age verification has taken place and that photo ID has been checked if the person appears to be less than 18 years of age. Mr. Maber is entirely aware, of course, of his role in providing liaison with the police, and if it assists in answering that question, that the duties of he and his staff in addressing the issues that may arise from the consumption of alcohol in public houses doesn't simply extend to not selling alcohol to those underage or those who are intoxicated, but for example, there was an incident whereby an individual who had consumed alcohol at the premises and so would have been over the legal limit attempted to drive away, and he and his staff, I am instructed, stopped the individual from driving away and in fact telephoned the police so as to prevent that from happening. It is, in my submission, a perfect example of a DPS performing their roles and responsibilities and also promoting the objective of the prevention of crime and disorder. That is obviously a situation where if the individual had driven away, the DPS could have said, well, my duty's finished here. But no, in recognition of his duties more generally, Mr. Maber called the police that an individual was attempting to drive whilst intoxicated. I hope that answers the question. And unless if I've missed something, then I'm very happy to come back.
Thank you very much. I think that was most of the points that I feel were being asked. The only other thing in there that I think you briefly touched on is the concept that the DPS is held to a higher standard perhaps than other people. And I think that the point that Chris might have been trying to link to that was going back to the personal convictions. I'm satisfied that there was sufficient in Mr. Day's statement that I don't need any further elaboration on that particular link, because I feel that we would merely be rehearsing those arguments again. Okay, Chris, did you have any further questions for Mr. Day and Mr. Mabbott?
No, ma'am, thank you.
Lovely, thank you very much. I will just for procedure ask Mr. Warren, do you have any questions as the applicant's representative?
Thank you, no.
No, lovely. And then I will turn to my panel. I actually had a question that I thought wasn't going to be addressed in Mr. Day's main statement, and then he very gracefully went back and explained to us the precise reason why Mr. Mabbott was removed as the DPS. So thank you. You've taken away my one question for today. Gerald.
Thank you, Chair. Mr. Day, just could you explain to me what you're saying then is that his 3 convictions that are listed are not really relevant to this application, and really only the video that we saw in the private session is the relevant piece of information. Is that what you're saying, please? And just one other thing, although you may say we shouldn't perhaps be considering those points, I don't know, doesn't it maybe tell us something about somebody's behaviour and character? That's my question, please.
Well, would you mind if I answered them in reverse?
You may take them in reverse. Do I need to warn you to be careful? Probably not, but no, you know to be careful.
So as to the very vague assertions, they could, in principle, be relevant if they were specified and if the individual were given the opportunity of rebutting them. Because one knows that the devil is in the detail. And it might be suggested that there has been an incident that, for example, engaged the police, which took place near the public house. And I know of an incident that I'm instructed about, whereby in an alleyway that adjoins the public house, that is not part of the public house, there was an attempted, I believe it may have been a mugging by an individual of people who were not customers of the business, and the individual who attempted the mugging was not a customer of the business. But the business, the security staff, identified what had happened and called the police. Now that may well go down as a call from the Engine public house and there's an issue of crime, but it has absolutely nothing to do with the public house. It was in fact the public house staff preventing crime and disorder, or at least notifying the police that there was something in the vicinity of the venue. That's why it would be unfair to rely upon generic statements like that, because you as a body, which must make the decision, have no way of knowing to what they relate, the circumstances of it, and whether it actually properly would impact upon your assessment of whether Mr. Mabbott as the DPS would promote the licensing objective. So it's not that they can't be, they can be. And indeed, it's often the case if there's a premises license review, that's what it's all about. But there has been no premises license review, which is relevant in itself because it rather belies the truth of the matter. But it's also the case that without knowing any more detail, you cannot give it any proper weight. And in my submission, it's properly inadmissible. As to the relevance of convictions in someone's personal life, it's entirely possible, and indeed recognized within Schedule 4, that convictions within someone's personal life may have a bearing upon someone's suitability to be a license holder. So if, for example, someone has been convicted of, I'm trying to think off the top of my head, but I believe there is a conviction within the Act for fraud, because it might make the position of trust that's held by a DPS one where the licensing authority conclude this individual can't be trusted with it. But in these circumstances where you're dealing with a very personal matter and private convictions in no way bear upon his conduct at his place of work, that in my submission is simply of no real relevance at all. And it certainly does not, which is the real issue, amount to exceptional circumstances that would justify the refusal of this individual becoming the DPS again. It's significant in this case that he has already been one, And if I may, I'll just quote to you and your colleagues from the Section 182 guidance provided by the government on this. At 4.26, it talks about the police objecting to the designation of a new DPS. And it gives this example. The police can object where, for example, a DPS is first specified in relation to a particular premises, and the specification of that DPS has given rise to exceptional circumstances or concerns. For example, where a personal license holder has been allowed to retain by the courts to retain their license despite convictions for selling alcohol to children, and then transfers into premises known for underage drinking. The difficulty here is there has been a conflation of premises license reviews and variation of a DPS. And in my respectful submission, the material that you've heard in public session has very little relevance. And the material that you've heard in private session, I'll simply note this: that happened in the middle, well, you know the date that happened. You know also that Mr. Mabert was the DPS for some 4 months afterwards without any issue being taken. And so if the police seriously maintain that that matter is such as to mean he's not a suitable DPS or is of such significance, then the question is inevitably begged, why now? Why not before? And we respectfully submit it's because on a proper, sober analysis, if it reveals any concerns about judgment making in the performance of a particular role that is not the role of the DPS, then that is for another body to consider. And it's not, in my submission, relevant to these circumstances. If I may, I'll just check one other matter which may be of relevance, which was within your own licensing policy, but I don't think it's particularly on point. Bear with me one moment, please. No, thank you. That hopefully provides an answer to the question you've answered, and I don't wish to say any more.
Thank you very much.
Thank you very much, Mr. Day. And I will remind members of the subcommittee that Mr. Day was answering a question, not providing legal advice, and merely presenting his opinion on how we ought to appropriate weight in these matters, because of course you will know that the subcommittee will determine what weight to apply to which aspects of the evidence and arguments that we hear today. Just a reminder. Okay. Goodness me, I could make comments about acts and actions which speak to people's character and how we might do that, but I feel that that's best left for our deliberations, isn't it? Because I can't form that into a question. So do we have any further questions for Mr. Day and Mr. Mabert?
Not for me.
No, thank you, Councillor Thake. Councillor Bloxham shaking his head, and Gerald, I'm assuming that very full answer. Yeah, excellent. In that case, that concludes our sort of main thrust of hearing evidence in this matter and questioning and examining things. So I will move us to closing statements. And the first closing statement I would like to hear is from our licensing officer, please. Mr. Cobb.
Thank you, Chair. In light of the lengthy opening statement that I made, I think the only thing that I can helpfully add at this stage is there is a right of appeal to all parties to the hearing, and that right of appeal would be to the local magistrates court.
Goodness me, that's the shortest closing statement I've ever had from a licensing officer.
Don't admonish him, Madam Chairman. Don't admonish him.
I didn't want to get on your wrong side, Chair.
I wasn't an admonishment at all, Councillor Thake. I don't know if I want to say I'm impressed or not. However, we shall move swiftly onwards to Hertfordshire Constabulary.
Ma'am, thank you. I too will make it very brief. I simply believe that while I'm not able to assist in procedural and the minutiae of the legal submissions in this, I have a sworn duty to protect the public. By bringing this to the committee, I sincerely believe that Dale Mabert is not suitable on the evidence that you've seen in closed session particularly. I think I've heard nothing to tell me that behaviours are critical to the actions and the abilities of a DPS. And I respectfully disagree with the submissions I've heard, in as much as my position on it is that the constabulary look at the actions that have been taken by an individual and have to assess, is it in the public's interest and is it within our capabilities to remove that person or object to that person becoming a DPS. On this occasion, we've felt it necessary, and as you've heard, it's very unusual. We've felt it necessary, and it would be with serious consideration that we would bring this to your attention. So my representation is complete, my evidence is complete, but in my duty to protect the public, I have no option other than to say, I do not think that Dale Mabbott is fit and proper to be a DPS.
Thank you very much. I'm going to break with proceedings momentarily because I've noticed I've got legal advice with a hand up. So Ahamna, is everything okay?
Yeah, I just wanted to point out that within the guidance, that licensed authorities should look into the police as the main source of advice, and that we are considering, whether Mr. Mabbott, we are considering the prevention of crime and disorder as well. So I just wanted to highlight that as well.
That's fine. I do actually have a concluding segment which allows for our legal advisor to raise any legal points that have come up in the hearing before we go into closed session. So if you want to hold on to that and any further points, and then I'll take that after I've heard from Mr. Day. Thank you. That's fine. It's your first hearing. It's absolutely fine. It's a learning experience. Mr. Day, a closing submission, please.
Ma'am, I think
your internet connection's lagging quite a bit. Do you want to try turning the camera off and seeing if we still get your audio?
Yes, thank you. Can you hear me?
Yeah.
Thank you. Ma'am, my submissions earlier were opening, middle and closing.
Okay, I think we've lost that, but I heard that Mr. Day essentially made the
closing submissions.
Opening, middle, and closing. Yeah.
Madam Chairman, may I suggest if we all mute and all turn our cameras off, maybe it might work.
Okay, so if everyone takes.
Ma'am, can you hear me now?
Yes.
I think I've recognised what happened. I think there was something that came through on my email that attempted to download. So hopefully you can hear me now without interruption.
Yeah, you're okay.
Thank you. All I was saying was I think my earlier submissions were beginning, middle and end, so I'm not going to repeat those. I don't think there's anything I didn't cover there that I would cover in my closing submission. I would simply say this. Sergeant Adshead is, of course, perfectly entitled to indicate why the police object, but the fact that the police have objected is, of course, entirely different to whether you as an independent body analysing that objection properly and in accordance with the law concur with it. Your independent judgment in my submission is what counts, and in all of the circumstances we say that the appropriate action here is to allow the variation of the DPS, and in those circumstances it would not undermine the prevention of crime objective. Ma'am, unless I can be of any further assistance.
Not at this time. Thank you, Mr. Day. That was very brief. Okay, so we will wrap things up and conclude. Oh, sorry. I'm so sorry, Piers. It's one of those funny sessions, isn't it? Go on. Do you want to give me Green King's closing statements?
Yes, thank you much. And this is very brief, and it will be the briefest you've ever heard from me, Chair, as well. But I think there are 3 points that need to be made, and I'm anticipating the legal advice you're getting from the legal officer in this as well. The crime and disorder licensing objective obviously needs to be taken into account, and your legal officer is referring to paragraph 2.1 of the guidance in the police are the main source of advice. But if you read down through that and you read the guidance, they still have to provide evidence, and they still have to give you that evidence to make the determination prior to you doing so. It's not simply that they've made this case before you that's enough. They still have to provide the evidence. And indeed, paragraph 9.43 of the guidance is very clear on that any determination must be evidence-based. And my final point is this, and I think this is a slightly wider point, but definitely worth pointing out. The police raised in their closing submissions that the behaviours here are important. Well, the truth of the matter is, and has always been the case, Green King will work with the police and will work with Dale, as we have done previously, in relation to any concerns that have ever been raised. And that will be an ongoing position that I think it's worth stating here. Obviously the police have their view here. We and Mr. Day has put forward a different view. But that changes nothing, and I think it's worth noting, obviously, those relationships still continue to be very important to us. Thank you.
No, that's lovely. Thank you very much. So I'll move to the final concluding part of this bit of the hearing and ask our legal advisor. I will learn to speak properly as well. Can I ask our legal advisor to summarise any legal points that have come up in today's hearing that we need to be aware of when we go into consideration?
Oops, sorry, thank you. I think I've sort of pointed out the relevant guidance that we need to look into, and in particular the prevention of crime and disorder, the licensing objectives, but I don't think I have anything else to add.
Okay, thank you very much. And before we go away to consider our decision, do members of the panel have any questions for our legal advisor?
Nothing from me, Madam Chairman.
Nothing at all.
Thank you.
No, excellent, lovely. In which case, we are going to close the hearing. I will let Will or Louis explain whether that means we're going to put up a holding screen or whatnot. And myself, Councillor Morris and Councillor Bloxham will discuss what we've heard and come to our decision. As explained in the introduction, if there is any breaking connection, if one of us gets lost for whatever reason, Councillor Stake has been present clearly throughout the entire hearing as well, and will step into our shoes as a reserve member. So can I ask one of my committee services officers please to explain what's going to happen next?
Thank you very much, Chair. The subcommittee will now be retiring to make a decision in private. Public viewing the meeting are welcome to wait to listen to the decision. However, this might take some time. Once the subcommittee has made its decision, this will be announced via the live stream. If members believe that the decision will take too long, to avoid parties waiting, they may decide not to announce the decision live today. If this is the case, an announcement will be made to this effect by the subcommittee and the meeting will be closed. The decision would then be announced in writing within 5 working days of the meeting. Members and officers will shortly be receiving an invitation to a breakout room. The applicants may stay or leave if they wish. A hold notice will be displayed in the Zoom call and the live stream will continue. Please note that as the live stream is ongoing, anything said during this time will be recorded. Thank you. You should be getting the invitation.
Hello. Right, so we've reached a decision. Before we get back into the hearing properly, I just want to make sure that we've notified everybody that wants to be here and present for this part, that we're ready to make a decision. So I'll give people a couple of minutes to make contact, come back on camera, etc., etc. Okay, I'm assuming that the police have had to leave, Steve, and we'll just receive this via correspondence.
Yes, Chair. Sergeant Adsed's had to go, unfortunately.
Okay, no, that's absolutely fine. We did take an hour and 10 minutes, which is medium to normal time for us anyway. Okay, right then, ladies and gentlemen. Thank you very much for your patience and for waiting for us. I hope everyone was able to have a little bit of a break and catch some lunch before coming back and then moving on to deal with your afternoons. So I shall run through the decision that the subcommittee has reached. The date of this hearing is Friday, the 21st of January 2022. Members of the panel are councillors Gerald Morris, Simon Bloxham and Elizabeth Dennis Harburg. The applicant is Green King Retail Limited, and the premises concerned are the engine at 3 Station Road, Baldock, Hertfordshire, SG7 5BS. The date this application was made was the 7th of December 2021. This is an application to vary the premises licence to specify a new designated premises supervisor under Section 37 of the Licensing Act 2003. The subcommittee has read the material presented to it and listened to all the evidence and submissions. The subcommittee has considered the national guidance and the statement of licensing policy, and we've come to the following decision. The subcommittee has decided to grant the application. And we've determined that specifying Dale Mabbott as the designated premises supervisor will not undermine the licensing objective of prevention of crime and disorder, and wait, I've got an either or in my decision. I just need to engage my brain slightly, bear with me. The subcommittee has determined that specifying Dale Mabbott as designated premises supervisor will not undermine the licensing objective of prevention of crime and disorder, and there are not exceptional circumstances that it would be appropriate to refuse the application. We've considered statutory guidance, and we've also considered the licensing policy considerations. I do not propose to read out the numbers of the relevant sections of those documents. I don't think that will be helpful here, but clearly they'll be in the decision notice. Now, important part, the rationale for the decision. Having listened to the submissions of all the parties, including the proposed designated premises supervisor's representative and the police, and having reviewed the video material in the closed session, the subcommittee was satisfied that granting the application to vary the premises licence to specify a new DPS or reinstate Mr. Mabbott as the DPS, as it might be, would be consistent with the promotion of the licensing objective of prevention of crime and disorder, but note specifically that the police expressed their concerns regarding the behaviour of the proposed premises supervisor and his previous convictions. However, the subcommittee is mindful of Section 2.1 of the guidance, which states licensing authorities should look to the police as the main source of advice on crime and disorder. However, we were not convinced that there was enough material submitted at the hearing and in order for us to reach a different conclusion to that which we have made today. The subcommittee having regard to all the evidence and representation at the hearing today, has concluded Mr. Mabbott, as DPS for the premises, would not have an adverse effect on the promotion of the prevention of the crime and disorder objective. Noting the rationale for the decision, the subcommittee has been very careful to state it is based on the evidence that we have heard today and indicates that there was not sufficient evidence to support the police's arguments on this particular occasion. I will leave that point hanging for parties to consider. The commencement date, this decision takes immediate effect, and an appeal may be made against this decision by the applicant, although I can't see why, or Hertfordshire Constabulary. The appeal and appeal fee may be lodged with the Clerk of Stevenage Magistrates Court no later than 21 days after the date on which the parties were notified by the licensing authority of this decision. And there we have it. Thank you very much for your time and effort today. I believe a copy of this decision will be with you, I think, by close of play today, Mr. Cobb.
That's one for Will, and Will is far more efficient than me.
Yes, I can get it done in about half an hour.
Excellent, that's good. I will make sure that I give you a quick note as well in advance of you sending that out, because I noticed just one or two words or typos here and there as I was reading through as well, clearly, as I stumbled a bit. All right, in that case, everybody is free to go. I'm not going to comment on the substantive detail of this case at all. I don't see why anyone would want to hang around and talk, so please go and enjoy the rest of your afternoons unless I can help you with anything else.
Thank you very much, Mom.
It's just for me to say thank you on behalf of the applicant for your time and your colleagues' times today in the council and your members.
Thank you very much, Piers. It's a pleasure as always.
Always nice to see you again. Take care.
Thank you.
Take care, everyone.
Thank you.
Thank you. Bye bye. Right, how do I get off this?